Let's discuss now the implications with former Assistant U.S. Attorney Kim Whaley and former New York City Prosecutor Paul Callan. Kim, if I could begin with you. Based on the current makeup of the court, by the way, this is not by accident. This has been a pipeline of judges through the years, in part with the intention of putting judges on the highest court that might overturn Roe. Based on the makeup of the court now, what is the most likely outcome here? A trimming back of Roe v. Wade, or perhaps an overturn?
Well, Jim, I honestly don't see much of a trimming back as an alternative here. I think it's either going to be affirming Roe versus Wade, or it will be overruling Roe versus Wade. And that's because this is not a case in which there was pushing the line of viability or what was established, kind of tinkering at the edges. This is a straight shot at the heart of Roe versus Wade itself. They're asking to overturn it. And in the cert petition, the request to actually have this case heard, Mississippi stated, we're not looking to overturn Roe, but once Amy Coney Barrett was put on the court, that's when the tone shifted, and they're essentially trying to obliterate a constitutional right. Normally, we're talking about balancing what should the state's interest be as opposed to the women's interest here. The reason I think it could be reversed or overruled is because the very existence of that constitutional right is what's on the chopping block right now. And that's pretty unusual to say, okay, we have a constitutional right that's respected, we're going to now erase it. Normally, we're just going to say the state has more interest in protecting here. The argument is unborn fetal life, number 2, women's health, and number 3, doctors' integrity. But of course, women are 14 times more likely to die through childbirth than they are through safe abortion procedures.
Paul, if you're, given everything too that Kim just laid out for us, if you are, arguing against this Mississippi law, where are you coming at this from this morning?
Well, you make a clear argument that the Supreme Court in Roe versus Wade essentially set down a standard, and that was viability of a fetus. And at viability, you can't prohibit abortion after that point in time. Now, at that time, it was 28 weeks. Since that time, they've lowered that because the science has changed to 23 weeks in Planned Parenthood versus Casey. So I think in the end, this whole debate is going to be not so much about the elimination of Roe versus Wade and the right to abortion, but when's the appropriate time that you can start to put restrictions on abortion? The science is getting a lot better in this area, and we know that fetuses survive at a much earlier time than maybe they did in 1973 when Roe came down. So I'm not so sure that there will be a ban on Roe.
Kim, let me ask you this, though, because you look at the Texas law, for instance, there are no exceptions for rape or incest. Where does the law stand on this? Beyond the science of viability, the question of a woman's right to choose under those circumstances.
Right, and there's no exceptions for rape or incest with this Mississippi law. Again, this Roe versus Wade, the right to abortion comes from the 14th Amendment to the U.S. Constitution, which is a post-Civil War amendment that was designed to address the abuses of enslaving people, right? Families torn apart, forced pregnancies, rape, all of those things, physical abuse that was tolerated in America. The 14th Amendment was designed to address that. And so the idea is the 14th Amendment encompasses lots of rights. The right to marry, the right to contraception, the right to decide where our children are educated, the right to our own medical care, and the right to tell the state, listen, you can't interfere with my decision to end a pregnancy at a certain time. So the ripple effects, Jim, of this are, in my mind, from a constitutional standpoint, well beyond Roe itself. And I think this conservative court has to have that firmly in mind.
And it will be interesting to see how much that comes into play, because even in Roe, and correct me if I'm wrong here, but when they, pointed out the 14th Amendment, privacy is not specifically listed in there, but noted the right wasn't absolute. So in terms of the state, right, making that decision on potential life, which was really in the 3rd trimester, looking at all of that, looking at what the implications could be far beyond a woman's right to choose and her access to a safe legal abortion, Paul. What could the dominoes be that would fall there?
Well, I think that if the court does decide to keep Roe in place, but to place more restrictions on the right to abortion, i.e., saying, well, we have to go back to an earlier point in time. Now, Mississippi says the cutoff point is 15 weeks, which I think the court is going to find that's way too early. So I think what you're going to see is a court looking for keeping and upholding the Roe decision, but pushing it back to an earlier point in the pregnancy where a woman has to seek abortion. And after that time, it'll be harder to get abortions in the United States. I'd be shocked if they overrule it completely, because I think there'll be an enormous controversy. But, you know, you were talking about that right of privacy. That actually goes back to a Connecticut case, Griswold versus Connecticut, which had to do with Connecticut was trying to ban contraceptives at that time. And when the court looked at that law, clearly they thought it was absolutely absurd, but there was nothing explicitly in the Constitution about privacy. And they essentially said, well, there's a penumbra that comes off of other rights. That's the term that's been used to describe it, of the right to privacy, even though it's not mentioned in the Constitution. And that later would become the basis of Roe.
Right.
So Roe stands on very, you know, sandy ground in terms of constitutional doctrine. And I think that's why people worry about it being overturned.
I would disagree with that, actually. Griswold was preceded by Meyer versus Nebraska in 1922, 1923, where the court held that the state can't ban German language instruction in private schools. So the idea that the Due Process Clause enumerates our rights vis-a-vis the government just isn't accurate across many rights that I think we all just assume are going to be our own, there for us in the morning when we wake up as Americans.
Well, that might be the argument, Erica, we hear in that courtroom beginning today.
Could be. It'd be interesting to see what the questions are that are asked, as has been pointed out, as we, again, won't have a ruling until likely June. Kim Whaley, Paul Callan, appreciate you both joining us this morning.